further hearing in the appeals, the Queen on the application of Hallam and Nealon and the Secretary of State for Justice.
Well, Ms Rose, what have been the results of your negotiations?
My lady, I've negotiated 15 minutes. But 5 minutes from
Very tough
Justice.
negotiator.
10 minutes off the replies of Ms Williams and myself.
Very well.
When we broke yesterday, we were looking at paragraphs 133 and 134 of Allen. That's MS 973 behind tab 11 in volume 1. Mm-hmm. And these are the two key paragraphs in which the court explains why, even though Article 6.2 is engaged by Section 133, the decisions in that case didn't breach Article 6.2.
Can you give me the reference again, please?
Yes, my lord. It's tab 11,
Yeah.
volume 1, MS 973.
Right.
And paragraphs.
Paragraphs 133 to 134.
Thank you.
And at 133, the court disapproves, first, the approach at paragraph 25 of the explanatory report, and secondly, Lord Staines's test. And both of those tests are materially identical to the test which now applies under the amended section 133. At paragraph 134, the court finds that the decisions in this case did not breach Article 6.2, and it does so for three reasons. The first is that the Court of Appeal in Allen did not comment on whether the applicant should be or would be likely to be acquitted on the evidence as it now stood at the time of the appeal. And I emphasise on the evidence as it now stood, talking about the fresh evidence. Secondly, that the Court of Appeal did not comment on whether the evidence, in other words, the new evidence, was indicative of guilt or innocence. And thirdly, that the court only addressed the historical question whether, if the evidence had been available at trial, in other words, the new evidence, there would have been a case to answer before the jury. So those are the three reasons given. And the distinction that the court is drawing there is between the national authority, here the court, deciding on the basis of the new evidence whether the applicant was guilty or innocent, which would be impermissible, and the national authority simply deciding that the evidence was such that there was still a case to go before a jury, permissible. And all of the focus on that paragraph is on the impact of the new evidence. And then finally, at paragraph 135, the court ties that permissible approach to the function of the Court of Appeal Criminal Division and makes the point that the function of that court is to determine the safety of the conviction and not innocence or guilt. And you see that set out specifically at 135. The court emphasises, pursuant to the law of criminal procedure in England, it's for the jury to assess the prosecution evidence and determine guilt. The CACD's role is to decide whether the conviction is unsafe and not to substitute itself for the jury in deciding whether, on the basis of the evidence now available, again I stress that, the applicant's guilt had been established beyond reasonable doubt. So that's the key decision in Allen, and we submit it does determine this case. What we then have is three further cases where the European Court of Human Rights applies Allen to the old section 133. And the central one of those is Adams. Adams is volume 5, tab 58, MS 2202. And if you go first to 2206, paragraph 22, this is in the court's recitation of what had happened below.
Sorry,
you can see
paragraph 20.
Paragraph 22, my lord, at the bottom of 2206, and going over the page, you can see that the court there sets out paragraph 58 of Lord Phillips's judgment in Adams. That is very significant because paragraph 58 of Lord Phillips is the genesis of the argument accepted by the Court of Appeal in this case. It's paragraph 58 of Phillips where Lord Phillips says, even if the test was innocence, proof of innocence, it would be okay because your only question would be whether the new evidence proved innocence. So the court's aware of that argument, but the court does not endorse it. If we go on to the court's reasoning, paragraph 39, page 2211, you see at paragraph 39 the issue of compatibility of section 133 itself is addressed. This, of course, in its old version. And they say nothing in 133 calls into question the innocence of an acquitted person. And then at 40, they come on to the approach of the judges in the Supreme Court. And about a third of the way, or half the way down that paragraph on that page, Lord Phillips explained that the test for a miscarriage of justice would be satisfied where a new fact so undermined the evidence that no conviction could possibly be based on it. That test was broadly approved by the other 4 justices in the majority. The application of the test did not undermine the applicant's acquittal or treat him in a manner inconsistent with his innocence. The test did not oblige the court to comment on whether, on the basis of the evidence as it stood at the appeal, again looking at the new evidence, the applicant should be or be likely to be acquitted or convicted. Equally, did not require the court to comment on whether the evidence, the new evidence, was indicative of guilt or innocence. And then this, it is true that in the course of the judgment there was some reference to the question of innocence. The justices discussed whether section 133 required that the claimant conclusively prove his innocence to be eligible for compensation. However, it's clear this was roundly rejected by the majority of the justices in the case in favour of the broader test formulated by Lord Phillips. It's unfortunate that some of the language used in the judgment was liable to confusion and an undesirable impression as to the standard required for compensation. But in light of the clear test articulated by Lord Phillips, it should be apparent to any future claimant that questions of guilt and innocence are irrelevant to proceedings under 133. So, crucially, the court here is not saying it's okay to talk about innocence or guilt because you're only looking at it on the basis of the new evidence. What it's saying is the 4 justices in the minority who were applying that test would have been breaching 6.2, and the case is saved by the round rejection of that test by the majority. So again, we say Adams inconsistent with the Court of Appeal, in this case, consistent with our submission. And the same approach is then applied in 2 other cases. The first is ALF, it's the preceding tab 57, page 2196, and you can see at paragraphs 22 to 23, the reasoning we've just looked at is repeated. And if you look at 24, page 2200, the court says it's true that in his letter the Secretary of State made reference to innocence. Such reference was both unfortunate and unnecessary in light of the test articulated by Lord Phillips, which the Secretary of State clearly applied. And then about 2/3 of the way down, as the court explained in Adams, it should be apparent from the judgment that questions of guilt and innocence are irrelevant. And the same test is then applied in a case we don't have time to go to, but I'll just give you the reference to it. It's KF, tab 5, volume 5, tab 60, page 2235, and it's paragraphs 24 to 29 of that judgment. That then brings me to the amended section 133 itself, which is in the core volume of authorities, tab 2, page 699. And so it's volume 1 of the authorities bundle, my lady.
It's all right. I'm
Yes.
just wondering what those papers are.
Tab 2, page 699. And you have the original 133. Just one point to note here on the 3rd line where it says that the conviction's been reversed or he's been pardoned on the ground that Lord Phillips made it clear in Adams at paragraph 36, which is at page 870, that on the ground that there just means in circumstances where, because of course the Court of Appeal doesn't reverse a conviction on the ground that there's a miscarriage of justice. And then we come to the offending provision, 1ZA, that there has been a miscarriage of justice if and only if the new or newly discovered fact shows beyond reasonable doubt that the person did not commit the offence. And that is precisely the vice that's been identified by the European Court of Human Rights in Allen and in Adams and in the other cases we've looked at, which is that the public authority, here the Secretary of State, is being asked to express an opinion on guilt or innocence to a standard of conclusive proof. And that is unacceptable and breaches 6.2 and undermines the acquittal. And if we now then go to the Court of Appeal's judgment, which is in Appendix 1, page 209.
And am I right in thinking that it is an autonomous exercise on the part of the Secretary of State?
Yes.
I mean, it's perhaps most vividly illustrated in a situation where the appeal isn't resisted, and therefore there's no, the Court of Appeal is unlikely to go into the evidence in any detail in its own judgment.
Yes. He is being asked to evaluate the new evidence and decide from his perspective whether the new fact shows that the person did not commit the offence beyond reasonable doubt. And that is the vice. And if we then go to why the Court of Appeal rejected that, you'll find it at page 209. It's paragraphs 47 and 48 are the critical paragraphs of this judgment. So
Sorry,
at 47...
Forgive me, Ms. Rose, we're going
Yes.
to
The appendix 1,
Yes.
page 209, paragraph 47 of the Court of Appeal's judgment. And rightly accepted at 47 that if Section 133 required the Secretary of State to voice doubts or suspicion about innocence, it would be regarded as incompatible with 6.2. We say that is correct. And the error comes in the following passage, where they say the critical reason it's not incompatible is that it doesn't require the applicant to prove his innocence generally. The key issue is the effect of the new or newly discovered fact. And then at the end of the passage, the statute assumes that the Secretary of State proceeds on the basis the applicant's been acquitted, entitled to be treated as innocent, only required to look at whether the new or newly discovered fact and nothing else shows beyond reasonable doubt the person did not commit the offence. Now, we say that is an erroneous statement, which is actually meaningless. And the reason it's meaningless is this, because the context, and this is the point that was being made yesterday, context in which this question arises is only the following. First, that a person has been convicted. Secondly, that their appeal rights in time were exhausted. So either they did not appeal their conviction or their appeal was dismissed and the conviction was upheld. Thirdly, there is a new or newly discovered fact. And fourthly, the conviction is quashed because of the new or newly discovered fact. In that situation, the only thing that could conceivably result in proof of the person's innocence is the new or newly discovered fact. And that is because the context in which the Secretary of State is being asked to exercise that judgment is such that there isn't anything else that could cause anyone to conclude that this person is innocent beyond reasonable doubt. The second point is this. The Secretary of State cannot be considering the new fact in a vacuum, because the question whether the new fact proves the person's innocence can only be answered by looking at the new fact in the light of the other evidence that was produced at trial. If you take my own client's case, the question whether his innocence was proved by a saliva stain on the victim's blouse that DNA testing now shows comes from a different unknown man, whether that proves his innocence will depend on questions such as whether she says that the attacker touched her blouse. And that takes you back to the original evidence at trial. You cannot consider the proof of evidence in a vacuum. So we say that the approach of the Court of Appeal relies upon a distinction which is wholly technical and has no practical content, and which is inconsistent with the basic principle underlying the application of 6.2 in this area. And as Ms. Williams showed you yesterday, the European Court of Human Rights said in Allen at paragraphs 92 to 94, the reason why Article 6.2 applies here is because it's essential to ensure that the presumption of innocence is protected in a manner that is both practical and effective. And we say this is a semantic distinction which denies practical and effective protection of the presumption of innocence. In this context, in these circumstances, the exercise of judgment required by Section 133 will cast doubt on the person's innocence. And for those reasons, we submit this appeal should be allowed. Now,
over your 15
I am, my lady. On the declaration of incompatibility, all I wanted to say was that it's obviously the correct remedy. It's clear that this was a deliberate policy intent, and this is not a case where Parliament has yet been told that the statute is incompatible, and it needs to be given the opportunity to consider whether remedial legislation should be enacted under Section 10 of the Human Rights Act. That's all I intend to say. I'm very grateful for your patience and for the leeway. Thank you.
Well, thank you, Miss Rose. And in the circumstances, I'm not going to ask whether your junior is going to follow you. Yes.
Can I thank the Court for allowing Justice to intervene in the time available to me? Can I just indicate what I propose to do? I propose to say, make a few remarks by way of introduction to the printed case which the Court has. I then propose to take the Court to some passages from the parliamentary debate at the time of the consideration of the amendment to Section 133. We have made reference to that in the printed case, but
You have, and what's the purpose for which you're drawing them to our attention?
I had understood that following the discussion in court yesterday, that the court would be assisted by being taken to, in particular, the statements from the government in relation to the purpose of the...
So it's not for the meaning of the amendment, it's for its purpose?
Yes.
Well, we'll listen.
Yes, thank you very much. And then finally, I propose just to very briefly refer to the schemes for compensation in other jurisdictions, but I'm going to deal with that very briefly. The court has an annex which sets out in some detail reference to other compensation schemes in other jurisdictions.
And that's very helpful.
Yes. Can I then, by way of introduction, just make these submissions, if I may, please? Justice considers that the current statutory provision for compensation for victims of miscarriage of justice is both impractical and unjust, and for those reasons supports the submissions advanced by the two appellants. The root of the problem in our submission is that whereas the rationale for the presumption of innocence in criminal cases and the concomitant rules concerning the burden and standard of proof is that it's preferable in a civilized society for a person who is probably guilty to go free than it is for someone who is possibly innocent to be convicted. When it comes to compensation for victims of miscarriage of justice, the rationale, or the apparent rationale of the statutory provision is the exact opposite, that it's better that someone who may be guilty should not be financially compensated than that someone who is probably innocent should be so compensated. And by way of comment, we can do no better than to adopt an observation which was made so aptly by Baroness Kennedy in the House of Lords report stage, which is in our printed case. She said, to expect them, that is those who have been wrongly convicted, to prove that they were innocent beyond reasonable doubt, is to add to the injustice they have already suffered. And as recorded by Justice in its recent publication, with which I think the court has been supplied, called Supporting Exonerees, what one finds is that a consistent complaint from victims of miscarriage of justice is the state's failure to acknowledge the wrong that they have experienced. Many say that what they really desire more than anything else is an apology for what happened. And the importance of financial compensation in our submission is that it goes some way to provide a public acknowledgement of by the state of the wrong inflicted on the victim. And that would be an important part of the healing process. The observations and the comments are to be found at page 37 of that publication, from paragraphs 107 onwards, which refers to the work that's been carried out by the psychiatrist Dr. Adrian Grounds, who has treated and assessed many people who've been wrongly convicted. Can I then turn, please, and I am going to do this briefly, and I'm going to be well within my allotted time, I can reassure the court, to the material from the parliamentary debates. It's been handed up this morning. It looks like this. Not sure that is going to help. And can I start by going to tab number 4, which is the report of the Public Bill Committee stage when the clause was first introduced by the Minister for Policing and Criminal Justice, Damien Green. I'm afraid we don't have the column numbers, but can I ask the court to go to page 463, top left? So it's, in fact, 2-3 pages in.
Well,
You mean column?
isn't it?
Sorry?
It's column.
That's the
Column
column
4.
number.
That is I've got the columns on this one. I'm terribly sorry. On the other reports, we don't have the columns. Column 463, yes. And can I just refer to the way in which this was introduced by Mr. Green? The third sentence down in that column, the new definition will mean that compensation is paid only to applicants who are shown beyond reasonable doubt to have been innocent of the crime of which they were convicted. So that is the purpose as set out by the Minister. That will make the payment of compensation for a miscarriage of justice more transparent and more consistent. Moreover, it will reflect the government's view that compensation should be paid only to people convicted of an offence of which they could not have been guilty. He then went on, in 2 paragraphs down, to make this observation. He said that since 1988, there has been no settled meaning of what constitutes a miscarriage of justice for these purposes. Between 2008 and May 2011, the test applied was that of clear innocence, and that was based on the judgment of Lord Steyne in the case of Mullen. I just pause there for a few moments, as the court will be well aware, of course, there was a difference of opinion in Mullen as to the correct test between Lord Steyne and Lord Bingham. But be that as it may, what appears to be being said here is that the Lord Steyne test was the one which was being applied. Can I just also interpolate? If one goes to the statistics for compensation, and we've set them out in our printed case, and they're also in the publication to which I've referred, it doesn't appear, on the face of it, that there was a significant reduction in compensation payments between 2008 and 2011. And without the ability properly to analyse the precise basis upon which compensation was awarded, there must be some doubt in our submission that, in fact, the Lord Steyne as opposed to the Lord Bingham test was in fact being applied. But that is what Parliament was told at the time that the provision was introduced. The next section is the report of the report stage in the House of Lords, and this is where we don't have the column numbers, I'm sorry to say, but the court will be aware that Lord Panic introduced a proposed amendment which would have had the effect of substituting the test in the section with the test adumbrated by Lord Phillips in Adams. That was the purpose of it. And indeed, Lord Phillips himself, as he said, unsurprisingly, supported that proposed amendment. And one finds his intervention, or his speech, at page 11 of 45. Of course, in Adams itself, Lord Phillips concluded that Article 6.2 did not apply to the unamended section 133. During the course of the debate, he recognised that, particularly as a result of the analysis from the Human Rights Committee, that was not the correct way to approach it. And if one looks at his statement in the second paragraph at the bottom of page 11, he said the amendment's been recommended by the Joint Committee on Human Rights, which has advanced two reasons for supporting it. The first and lesser reason is that in determining whether there's been a miscarriage of justice as defined in the amendment, the Secretary of State or the courts in reviewing her decision will not have to infringe the presumption of innocence that is required by Article 6.2. And he says this is not true of the definition proposed by the bill. So he acknowledged that the new provision would indeed, in his view, infringe Article 6.2. Can I then move, please, to the statements which followed in the Commons? Can I ask the Court to go to tab 6?
I suppose we could note what Lord Brown and Eaton under Hayward said at page 17.
No, indeed.
So,
Indeed. I'm cherry-picking drastically from
Yes, of course.
but Lord Brown was consistent with his
yes.
his speech in Adams, and the underlying he made clear and always has made clear that the underlying rationale is to avoid those who may be guilty from receiving compensation. Can I then go, please, to how it was then dealt with? Because, of course, there was then a proposed amendment, and I know that the Court has already been addressed about this, so that the word innocence was removed, and the proof of the offence was substituted. And the debate then in the Commons was what was the difference, if there was a difference, between those between the original formulation and the amendment. And at page 551, we have the member for Helton Price and Hallam, Mr. David Davis, asking to be provided with an example of a case that would not pass one filter, would pass the other filter. Mr. Green said in the last paragraph of, well, the third paragraph down of his reply, everyone has been asking what's the difference between the original clause and this clause. Of course, the substance, he said, is not different. So effectively returning to what had been originally said, he'd originally said. However, we recognise that in this area, language is very important, and precisely because of the emotion that surrounds the word innocent, there is a case for reviewing the reference to that word, which has been so controversial, and that is what we have done. So it was really, if I can say so, no more than a cosmetic amendment. Page 8, he said this, the top of the page, we remain strongly committed to ensuring that compensation is paid only to those who genuinely warrant it, however, and then, in our view, compensation should be paid only to applicants where it is shown beyond reasonable doubt that they did not commit the offence. But then, one moves over to after an intervention by Mr. Durkin, to page 9, the second paragraph. He said this, I'm aware that in both houses there's been a misconception that applicants would somehow be required to prove that they did not commit the offence before compensation could be considered. I can categorically say that that is not the case. Applicants do not have to prove anything under the existing criteria, and nor would they have to do so in future under this proposal. And it's our submission that that is difficult to understand, because it appears to contradict what had previously been said, that applicants do have to show beyond reasonable doubt that they did not commit the offence. So the reassurance given to Parliament does not appear to have been based upon the way in which the clause was in fact formulated. And then if I can please move to the debate in the House of Lords when it returned, it's tab 7. And this is Lord Falk speaking for the government. And can I ask my lady and my lords to turn to page 3. There's a reference to the time, 5 o'clock. And he said this, if your lordships accept the government amendment, the word innocence is removed altogether from his consideration of the application. Let me make it perfectly clear. The difference between what we now suggest to be part of the bill and what was originally there is only a question of words. It would not result in a different determination in any one case, but words matter in this context because there is a deep visceral unease about anything that may be said to run contrary to the presumption of innocence, hence the changing of the words. Those in our submissions are the relevant passages which do assist the court in determining what the intention of the section was. And it really comes back to the way it was expressed by when it was first introduced by Damien Green. Can I then please move, and I'm going to do this very briefly, to the way in which compensation is dealt with in alternative jurisdictions. As I've said, we've set out a table. But the most helpful comparator is Scotland. And we have, at paragraph 41 of our written case, we've referred to the scheme in Scotland. We have also referred to, provided a link to the website which deals with it. We haven't printed that out. But section 133, the unamended test, is still applied. There's also an ex gratia scheme, but there is guidance for how the section 133...
Yeah. The difference in Scotland is that the test for quashing a conviction is miscarriage of justice.
Yes.
And the phrase is given a much wider meaning than it
Yes.
has in section 133. And so, as you say in this paragraph, effectively, appellants are automatically, more or less automatically, compensated if they're successful.
I mean, there is the obvious problem of comparisons by the jurisdictions because of the different regimes, but our essential point is this, that it is perfectly possible to do justice to those who have been wrongly convicted by the provision of adequate compensation. It should not be a problem. The issue really for this court, when considering the declaration of incompatibility, is, when it comes down to it, whether or not the court should revert to the Adams criteria. That appears to be the position. It has always been Justice's position, and I need to make this plain, that the Adams criteria themselves are not sufficient, do not provide sufficient safeguard for those who have been wrongly convicted. But of course, that in a way is outside the ambit of the court's powers in this case. But that is Justice's position. Can I just really, by way of conclusion, just make this submission? The reality is that it is now virtually impossible for a genuine victim of a miscarriage of justice to get compensation. It's not completely impossible, but it's extremely difficult. The two cases before the court provide very powerful examples of the injustice of the operation of the current provision. Justice's publication makes the point that on analysis, compensation would not have been available for the notorious miscarriages of justice of the 1980s and 1990s, the well-known cases, the Birmingham 6, the Guildford 4, Sally Clark and Angela Canning's, and the Cardiff 3. It's our submission that the situation in which we find ourselves now is lamentable, and there is real substance in the appeals before this court. I think I've just trespassed a little over there for 15 minutes.
Well, thank you very much indeed, Mr. Blackson. Thank you.
My Lady, my Lords, by way of overview, the respondent makes two main submissions in response to these appeals. And the first is that this court was correct to decide in Adams, endorsing what my Lord Hughes said in the case of Allen in the Court of Appeal, that Article 6.2 is not applicable to the process of determining eligibility for compensation under Section 133 of the Criminal Justice Act of 88. We, of course, accept the Grand Chamber of the Strasbourg Court has concluded to the contrary in the Allen decision. But for the reasons we'll come to, we do submit that the analysis of this court in Adams remains compelling, and the Strasbourg Court's reasoning to the contrary lacks sufficient force of reasoning to be followed. And indeed, Section 133 is a special jurisdiction, marked by particular features, which I will address shortly, where the presumption of innocence as a concept is neither necessary nor apposite. And contrary to the impression that may have been given yesterday, Allen and the UK is indeed the first time that Strasbourg has sought to apply Article 6.2 to Section 133 type proceedings. And I mean by that those which track Article 14.6 of the International Covenant, or indeed Article 3 of Protocol 7. And so whilst this court's clearly required to take into account the decision in Allen, in deciding whether to overrule its previous decision in Adams, we do say this is one of those rare cases where there is both a need for and room for some further constructive dialogue. The second cause submission is that if Article 6.2 is treated as applicable in accordance with Allen, we say it is demonstrably not violated by the new test laid down in Section 133, either in principle or perhaps equally importantly, by the decisions in these two cases. And we already know that the Strasbourg Court has concluded that Article 6 is not violated by Section 133 in its previous form. And we say, contrary again to the submissions you've heard, it's misguided to suggest the Strasbourg Court was opining on the amended form of Section 133 in its current state, which of course wasn't before the court in Allen at all. And we do refer to what Lord Phillips said at paragraph 58 of the Adams decision itself, and that's MS 877. I don't need to turn it up now, but we've already looked at it, that on no view does Section 133 make the right to compensation conditional on proof of innocence by a claimant. The right to compensation depends upon a new or newly discovered fact showing beyond reasonable doubt that a miscarriage of justice has occurred, and whatever the precise meaning of a miscarriage of justice, the issue in the individual case will be whether it was conclusively demonstrated by the new fact, not whether the claimant was in fact innocent, and the presumption of innocence will not be infringed. We say the same point was made by Lord Hope in the Adams case at paragraph 111, and the reference for that is MS 893-4 in volume 1. The same point, of course, was made both by the Divisional Court in the judgment of Lord Justice Burnett and by the Court of Appeal, in these cases, by Lord Dyson, sitting with Lord Justice Leveson and Lord Justice Patton. We will show, I hope shortly, that even on the most extensive or broad application of the Strasbourg jurisprudence, there is no basis for suggesting violation of Article 6.2 when you apply the 1ZA test, if I can use that as an abbreviation. And we do say in that regard that the appellants have mischaracterised the nature of the statutory test. It doesn't require an individual to prove their innocence, as has been submitted. Indeed, the basic premise on which the Secretary of State acts when applying the test is that the applicant is indeed presumed innocent and is treated as such by the acquittal from the Court of Appeal Criminal Division. What the Secretary of State has to decide and is exclusively focused upon is the effect of the new or newly discovered fact, where it has led to the quashing of the conviction. The person, of course, is presumed innocent, but the Secretary of State is addressing whether there's been a miscarriage of justice as so defined under the Act. And that arises if it's the new or newly discovered fact that establishes beyond reasonable doubt that the person didn't commit the offence.
I mean, does that show that if the new or newly discovered fact is DNA, and this is a rape charge, and there's only one identifiable DNA on the victim, and the newly discovered fact is that it doesn't match the defendant's, new tests and more sophisticated tests prove that, then you could get compensation, but you couldn't get compensation if the new fact by itself showed nothing particular. It might just show that a letter was delivered on a particular date. It could only prove innocence if treated in conjunction with all the other evidence in the case. I mean, if that's the position, then your thesis confines the operation of this section very minutely to a very minute number of cases indeed.
Our Lord, it does, and that's right. It is confined to circumstances where the new or newly discovered fact
By itself
has that effect, yes.
I mean, you must be entitled to look at something else, namely the nature of the case, I suppose. So, I mean, that's one point made against you, that you're isolating a fact, but
well, my Lord,
you can't do at all. But if you can do it, it seems to have a very strange effect.
well, Lord, there's an example of precisely the case your Lordship's putting to me, referred to in the Court of Appeal Criminal Division's decision in the second appellant's case, Mr. Nealon's case, the case of Hodgson, where DNA evidence had that effect of demonstrating that the person who had been convicted of that case hadn't committed the offence, notwithstanding, indeed, the fact that there had been confessions by the individual. So that would bring into play other issues, such as whether the non-disclosure or may have been partly a consequence of their own, what they said in terms of the investigation. But yes, that is an example of that case. But can I put the converse? And I'm just going to come to in a moment, that there, of course, may be many reasons why the Court of Appeal Criminal Division quashes a conviction. They may be a mixture of newly discovered facts and not newly discovered facts. And in those circumstances, the safety of the conviction may be quashed for a number of different reasons. The Secretary of State's function under this section is only to look at the effect of the new or newly discovered fact.
I mean, a question is going to be obvious, and you'll have to explain how you can do that. I mean, how can you blinker yourself? How can you avoid looking at the context of the case as a whole? I'm sure you'll come to that.
Well, I will come to it, but I'm going to do it, I think, preferably by reference to the facts of these cases, because indeed, in the first case, Mr. Hallam's case, there were a number of facts which led to the quashing of the conviction, including a reappraisal of one of the directions given to the jury. And my submission, is, when we come to it, is in fact the task imposed on the Secretary of State of looking under this new test as to the new or newly discovered facts effect is actually a simpler one than it is the case under Category 2, as it stands or stood under Adams, where, of course, the Secretary of State's required to look at the question of whether the newly or newly discovered fact so undermines all the evidence that no prosecution could be based upon it. But can I show you that in the context of the specific case of Mr. Hallam? I have emphasised, of course, there is this focus on the new or newly discovered fact. And that, of course, means that the Secretary of State is not commenting on what the Court of Appeal described as general guilt or innocence. And indeed, there are cases, and I'm going to show you them in the law, the case law, where someone can demonstrate their innocence for other reasons. And Miss Howells, in the case of Bateman and Howells, Miss Howells, Mr. Matveyev and Mr. Bakovsky in the Strasbourg context were such individuals. They were able to demonstrate they'd been convicted of offences which weren't in fact offences at all. But they would not be eligible for compensation under Section 133, nor indeed under Article 14.6, because of the restrictive criteria that apply to that provision. And so one can contemplate and indeed see cases where someone may have their conviction quashed for a number of reasons. They may be able to demonstrate their innocence as part of those reasons, as I'll show you. But that would not qualify them for compensation because the test is focusing specifically on one particular criterion. And that means that one takes the Secretary of State's function away from the thing that Strasbourg is concerned about, namely assessing in an overall sense whether someone is guilty or innocent after they've been acquitted following a trial or a discontinuance of proceedings. And I do submit that Strasbourg does have a concern about the language used, and indeed there was some discussion about that yesterday in the context of Category 2 being acceptable, and indeed there is some case law which illustrates the difficulties of language even when used in the civil compensation context. And I'll show you the case of Orr in Norway, where reference to violence being used in establishing civil law liability was found to cross the line, even though that is precisely what had happened from a civil law perspective. But language, to Strasbourg's mind, is important. Therefore, when the references you've just seen to the language of 1ZA referring to not committing the offence are capable of having that fine balance in Strasbourg's mind. I wanted to deal with both those two core submissions in a little bit more detail, but there are two other preliminary topics I just want to touch on first. And the first is the facts, and I hope I'll be forgiven for turning back to the facts of these cases to test the propositions. And the second is the legal background to Section 133 itself. On the facts, can I pick up on the point we just discussed a moment ago by reference to the Court of Appeal Criminal Division's decisions in these cases? And if one turns in core volume, the core volume to page 244, so tab 8, there is the Court of Appeal Criminal Division's decision in the first appellant's case. And I invite the court to read this decision, and indeed the decision letter that follows, bearing in mind the general aim of the Strasbourg Court, as expressed in paragraph 94 of Allen, that's MS 963, of avoiding public official authorities treating someone as though they are in fact guilty of the offence charged. In the Court of Appeal Criminal Division's judgment, you'll see there's a detailed discussion of the background to what was a complicated set of circumstances which had led to the conviction, beginning from paragraph 2, where someone had been assaulted, two people in fact had been assaulted, one had subsequently died in a group attack, and all of the difficulties of identification and identifying who was responsible for what arose in the context of that case. And can I just draw your attention to paragraph 9, where There was an issue about a witness in the case, Christopher Bissett, who had given evidence, and at the end of paragraph 9, page 246, it says, "You will have seen there was a direction by the judge to the jury to the approach to whole of Mr. Bissett's evidence, including the parts which potentially exculpated the appellant with caution, because Mr. Bissett may have had an improper motive in giving evidence, that is a reason to lie to protect himself or his brother by deflecting blame onto the others." There is a detailed discussion of the identification evidence by the court, which follows in the pages, paragraphs, and I'm obviously not going to read it all out, but the context is to consider the quality of the identification evidence and the difficulties there were with that evidence.
Sorry, Mr. Jackson, I don't quite understand. Why are you taking us to paragraph 9?
My Lord,
What's the significance of that for the question that we're interested in?
the significance of that, well, I'll just tie the paragraphs together. Paragraph 52 of the same judgment on page 256,
Yeah.
that one of the grounds of appeal taken by Mr. Blackson, I believe, hadn't been taken previously on the original case.
The direction was wrong.
That the direction to ignore that evidence had been wrong. And just to, so no one's left in suspense, when you get to the end of the judgment, paragraph 77, 78, and 79, the Court of Appeal Criminal Division took into account not just the new evidence relating to the alibi and whether or not the case that had been concocted was now affected, which it was, but in addition, paragraph 79, finally there's the point, not spotted by anyone before these proceedings, the jury may not have appreciated they were free to rely upon exculpatory evidence. And Mr. Bissett, in our judgment, the cumulative effect of these factors is to undermine the safety of these convictions. Now, there are many cases where the Court of Appeal Criminal Division may rely upon a cumulative effect, both of new or newly discovered fact evidence, or indeed a reappraisal of identification evidence at the time, or indeed of other factors which don't qualify as new or newly discovered facts. In the case of Van Dukwa was, of course, the failure to spot an available defence that in that case was available to the defendant. But this is an example where there are cumulative factors, one of which isn't a new or newly discovered fact at all. That led to the quashing of the convictions. Under the Category 2 test, of course, the Secretary of State's function would be to distinguish the new or newly discovered fact issues, which would relate to 77 and 78, and strip out the relevance of the additional exculpatory or wrongful direction on exculpatory evidence. Whether that has a specific consequence in this case, it's not for me to speculate, but it just gives you a clear example where there can be a mixture of factors that go through what the Court of Appeal Criminal Division is doing as part of its function. The Secretary of State, under Category 2, having removed the paragraph 79 factor, will then have to decide whether there was a miscarriage of justice under the term Lord Phillips' expression of that test, seeing whether the other new or newly discovered facts so undermine the evidence that no prosecution could be based upon it. And that may be a more involved exercise in certain cases where the Secretary of State has to disentangle that process, but we know that exercise is compliant with Article 6.2, even though it requires an appraisal of the evidence. By contrast, in a case of this kind, where the new or newly discovered fact under the 1ZA test has to show the person didn't commit the offence, the Secretary of State will have the benefit, as in these two cases, of the Court of Appeal Criminal Division's own conclusions. And in that circumstance, can I just ask the Court to note that one of the submissions made, paragraph 49, page 255, to the Court, Mr. Blackstone summarised the appeal in this way, and then you can see that Mr. Blackstone, in light of what was said in Adams, specifically invited the court to conclude and state that the appellant was innocent of the offences of which he was convicted. And the court said, as will become apparent, we were not satisfied it would be appropriate to use that power on the facts of this case. And in those circumstances, where the Court of Appeal Criminal Division has made it clear as to how far the evidence goes, and if you want the reference to how far it goes, you can see that from the later explanations of what the alibi, how the new evidence affected the alibi evidence. It didn't provide confirmation of where the appellant was on the night in question, but it did affect the question of whether the alibi had been concocted.
Mr. Strawn, I wonder whether you can help us on subsection 1 of section 133,
Yes.
which is the sort of the way into this system altogether. The conviction has got to be reversed, let's forget about pardon, on the ground that a new or newly discovered fact shows beyond reasonable doubt that there's been a miscarriage of justice, now as defined. So the conviction has got to be reversed on the ground of a new fact which shows beyond reasonable doubt. Now, you've mentioned cases where the conviction is reversed on a number of grounds. And so we read, is this common ground, that we read this as meaning on the ground in whole or in part.
Yeah, so I think Lord Phillips dealt with that as in the circumstances where, so that he construed and the majority of the court accepted that it didn't mean exclusively on the ground that, but in circumstances where there was a new or newly discovered fact. So that's the way it's been approached.
Yes, well, that's helpful. And then, of course, it says, on the ground that the new fact shows beyond reasonable doubt. Well, a reversal of a conviction would never be cast in whole or in part upon a ground that a new fact shows beyond reasonable doubt, would it, Mr. Strawn?
My Lord, no, it doesn't. It's unlikely to be expressed in that way. However, that is a criterion that flows from Article 14.6 itself. The word used there is conclusively,
yes, quite.
And it's been translated into domestic law as beyond reasonable doubt.
As a matter of practice, Mr. Strawn, surely sometimes the judgment of the Court of Appeal will do exactly that. It's clearly not obliged to, and there are lots of cases where you can't. But in the kind of case where, for example, new advances in DNA analysis of a substance that can only have come from the offender, rather depends where it's found quite often, but in that kind of case, would you not expect the Court of Appeal, in quashing the conviction, to say that the fresh evidence demonstrates conclusively, or if you like, beyond reasonable doubt,
my Lord,
the person in question could not have committed the offence?
I would certainly, I can put it in this way, I would certainly expect, and indeed practice indicates, the Court of Appeal Criminal Division will express its conclusions as to what the effect of a new or newly discovered fact is on the case.
Well, and
if it, in the case of Hodgson, for example, I'm going to turn you to the reference in a moment, it made it clear that that demolished the case because it showed the individual couldn't have committed the offence. Whether the Court of Appeal Criminal Division would use necessarily the language of beyond reasonable doubt or conclusively, I cannot speculate. But what I can submit, and I do submit, is the Court of Appeal Criminal Division's judgment will always explain what effect the new or newly discovered fact has on the overall shape of the case in a way that enables the Secretary of State to exercise the function readily under 1ZA. This is such a case, I've just shown you, because when asked The Court of Appeal made it plain. And what I wanted to do was complete the picture by showing you the Secretary of State's decision letter, which in fact faithfully reflects the reasoning expressed in the Court of Appeal Criminals Division's judgment. And what is more, the exercise of tracking the Court of Appeal Criminal Division's decision is an easier one and takes one less into the territory of assessing the overall evidence under 1ZA than it would have done under Category 2. Here's a case in point. The Court of Appeal Criminal Division has made it clear what the effect of the new or newly discovered fact evidence is. It doesn't go so far as to demonstrate the individual didn't commit the offence. And
if the Court of Appeal Criminal Division had acceded to Mr. Blackland's application and had made it clear that the decision to pronounce the appellant innocent was motivated not only by the new or newly discovered fact, but also by its reappraisal of the evidence given at trial, what would the options be for the Secretary of State?
My Lord, strictly speaking, if it were done by a reappraisal of the evidence, that is an exercise which is different to that which the Secretary of State is required to undertake, because that would be a reappraisal of innocence generally, and not the function of the Secretary of State under 1ZA, which is simply to look at the new or newly discovered fact.
Right, so we would have the somewhat anomalous position that the Court of Appeal would pronounce that it considered that the appellant was innocent, but the Secretary of State would conclude that he was not entitled to compensation.
My Lord, not anomalous in this sense. Such announcements would be expected in the case I'm about to show you, for example, in the Bateman and Howells case, where in that case, Your Lordship may recall, Miss Bateman was convicted of an offence of a bylaw where the bylaws were subsequently challenged and found to be invalid, and there had been no consequential offence committed because they were valid on their... so the Court of Appeal in that case can declare someone innocent because no offence has been committed, but there would be no entitlement to compensation.
That's a world away from the circumstances of these appeals.
My Lord, that is, but it demonstrates what I'm going to show you in a moment, that the Section 133 is based on very restrictive criteria which flow from Article 14.6 itself. And the imposition of such criteria is a legitimate process under that statute and that article right, and doesn't take you into the territory of looking at general innocence or guilt of an individual when they come before the courts.
Let me just get it straight in my mind. What you just said is that if the Court of Appeal had found innocence on an overall basis, a general review of all the factors, then the Secretary of State wouldn't be entitled to take account of that because of the confines of 1131ZA. Have I put it right?
They wouldn't be, well, I say entitled.
He wouldn't be entitled.
Wouldn't be entitled to.
He's required only to look, on your case, at the new or newly discovered facts and what that shows by itself. I see. Whereas, I mean, the strength of, I suppose, has the European Court ever considered a case where the Court of Appeal made a finding like it made in this case, namely that it refused to find innocence?
I'm not aware of that occurring because...
I mean, the Court of Appeals, the European Court's concern has been domestic authorities expressing conclusions contrary to the conclusions implicit in the acquittal, whereas here the domestic authority would, on the face of it, be expressing a conclusion precisely the same as the domestic.
My Lord, I'm going to show you the authorities in a little bit more detail, because what actually emerges is that where one is not having a final acquittal, a finding by a jury, you are certainly allowed, as both the court and indeed the subsequent decision maker, to voice suspicions That's the line of authority, or the Minelli principle, in contrast to the Seconina type principle.
Well, it could also be said to be implicit in category 2, in Lord Phillips's
Indeed.
formulation. I mean, if there's something which is capable of being put before a jury, there must be one would have thought, a suspicion.
Indeed.
Which you can voice, apparently.
You are entitled to voice. Indeed,
Yes.
when I show you the authorities, you'll see you can voice them in rather trenchant terms. And I'll show you those in a moment. Can I just give you the reference to the Secretary of State's decision letter, which is at core volume 272 and 273. And you'll note that from the paragraph on page 273, that the Secretary of State's decision about the new evidence, in fact, tracks exactly what the Court of Appeal Criminal Division said about what the new evidence did. And, of course, in my submission, therefore, the Secretary of State's both performing the limited function under 1ZA required, but also tracking what the Court of Appeal Criminal Division has concluded. That's 273. The same exercise, again, but very briefly, in the case of the second appellant. The Court of Appeal Criminal Division's judgment is on, or begins at page 396. And in the judgment by Lord Justice Fulford, you can see a similar process, an assessment of the evidence and consideration of the new or newly discovered fact relating to the DNA evidence. I'm not obviously attempting to read it all out, but I'm just drawing the court's attention to it. It runs from paragraphs 4 through to 33. And the conclusions then at 34, 35 and 30, paragraphs 34, 35 and 6. Can I just draw attention, though, before we get there, page 401, paragraph 26, there's reference to the Hodgson case, which you can also find reported, but in answer to the question of how you can indeed have evidence which demonstrates conclusively someone didn't commit a crime. There is obviously the Hodgson case itself. It proved the appellant was not the killer and rapist as in the final sentence. And if you go to paragraphs 34 to 36, the conclusions of the court as to the effect of the new evidence, the new DNA evidence, are expressed. At paragraph 35, without reading all out, you'll see it's clear that unlike the situation foreline in Hodgson, the fresh evidence has not demolished the prosecution case. And the reasons for that are explained in more detail, which I don't go into, because they were inconclusive in the same way as Hodgson wasn't. And you can see, though, it affected the safety of the conviction, leading to the quashing of that conviction. Paragraph 36, the prosecution which had defended the case couldn't show the result would have been the same, although their explanation of the evidence provided a dimension to the debate that required serious consideration. And I like analysis. If you look at the decision letter of the Secretary of State in this case, which you will find in the same volume, page 234, I think it is. No, I've got the wrong, apologise. I'll find you the reference to the decision letter. And sorry, it is 422. 234 internally, 422 electronically, sorry. And you can see the critical paragraph, page 423, the Secretary of State's explanation as to the effect of the new evidence tracks that of the Court of Appeal Criminal Division. And it didn't fulfill the statutory criterion of 1ZA.
I'm sorry to go back to Mr. Hallam's case again, but if Mr. Blaxland's application had been acceded to by the Court of Appeal and they pronounced Mr. Hallam innocent, and they made it absolutely clear that they relied solely on the new or newly discovered fact, what would the role for the Secretary of State be?
The role of the Secretary of State would then be to apply 1ZA to decide for himself whether that new or newly discovered fact demonstrated beyond reasonable doubt that the person didn't commit the offence.
So theoretically, the Secretary of State could second guess, or perhaps second guess is the wrong expression, could overrule the decision of the court.
Theoretically, and that's a point your Lordship made in the Adams case itself, that the function is still there for the Secretary of State, but you went on to observe that any such decision would have to be reasoned. And if second-guessing the Court of Appeal Criminal Division's reasoning and conclusions, the Secretary of State's decision, in order to withstand scrutiny, would need to explain precisely why the Secretary of State was differing from the Court of Appeal Criminal Division's analysis. So, in theory, in practice, it's less of a prospect, but it's there, subject to the normal controls of administrative decision-making.
One can understand why Mr. Blaxland asked the court to make a positive statement of innocence in the first appellant's case, and why the Secretary of State's decision letter founds on the court's unwillingness to make such a statement. But it might be thought to be a very unfortunate development if effectively the CACD were to develop a practice of giving, in fact, two grades of decision, a simple quashing of a conviction as unsafe, and one where there was, in addition, a positive statement of innocence.
Well, that ability exists, as I've illustrated just from the facts of this case. It exists there. It will only arise, of course, in circumstances where the appellant considers there's a reasonable basis for making the application. In fact, Mr. Blaxland's application wasn't made simply on the new or newly discovered fact that the Court of Appeal took into account, but other contentions about the evidence which were actually not accepted by the Court of Appeal.
Well, if you are the Court of Appeal hearing a criminal appeal of that kind, it's not simply a question of compensation. If the evidence demonstrates that the person in front of you clearly didn't do it, you're letting him down if you don't say so.
My Lord, what I do submit, which effectively adopts that point, but it is difficult to conceive of any circumstances where the Court of Appeal would not express its reasoning as to the effect of the evidence in a way which enables the Secretary of State to readily understand whether 1ZA is met.
Never mind the compensation. He's entitled to know if it be the case. There may not be all that many cases where it's true, but if it be the case that he has been exonerated, the case has been demolished, to use the language which is borrowed here and there. I may, of course, have got it wrong for years, but I find it almost impossible to conceive that a Court of Appeal would not say so. In fairness to him, never mind the compensation.
That is my submission, and that is why, in practice, 1ZA is far simpler for the Secretary of State to apply without getting into assessments of evidence under Category 1.
Yes, there's no difficulty.
Well, simpler in the sense. Sorry, simpler in the sense not just of whether it's administratively easier, but simpler in the sense it doesn't take one into the territory of weighing up the evidence to assess whether a jury could possibly have convicted upon it. That assessment process, in my submission, takes you further into the territory of Strasbourg's area of concern, which is about assessment of overall innocence or guilt, because we're getting into questions of the overall effect of the evidence.
Isn't that a matter which the Court of Appeal Criminal Division almost, well, very frequently does anyway for a different reason, namely it has to decide whether or not to order a retrial?
Yes.
And I mean, at that stage, it's bound to assess the nature of the case and whether it can stand up at all.
My Lord, that can occur, but it doesn't occur always. And Miss Allen's case is a very good example where the events happened so long ago that the reasons for not ordering a retrial weren't an assessment.
Or you served your sentence. I mean, we know the form, but it can arise.
Can arise, yes.
And not in front.
But it doesn't, well, it can, my Lord, I really accept it can arise, but it doesn't always arise, and it therefore, the Secretary of State still has to perform the function under 1ZA, or indeed Category 2.
Yeah, look, the concern I'm voicing isn't questioning the practice of the court that Lord Hughes has described. Although speaking for myself, I can't think of a single criminal appeal I've ever sat on where I've made a declaration along these or statement along these lines, but maybe our experience has been different. But the point is that structurally the weakness in Section 1331 might be said to be that the criminal process has no concept of innocence and isn't directed towards findings of innocence. It's all concerned with guilt and findings of guilt. But that Lord Judge's remark in Adams enables a practice to develop which the structure of the section encourages, namely, if somebody's conviction looks like being quashed on the basis of fresh evidence, then and he's been in custody, then it's going to be natural for those representing that person to seek to have not merely the conviction quashed, but in addition the court make a finding of innocence.
Well, my Lord, clearly people may, and that's what happened in this case. It will, if sought, the Court of Appeal Criminal Division will be able to, well placed to express its view on the effect of the new or newly discovered fact. But certainly one must remember the Court of Appeal Criminal Division is not there to sift out what are new and newly discovered facts and what aren't in making an overall assessment, because that's not their function. Yeah. They are just looking at safety of conviction. But the point is, for 1ZA purposes, that certainly if one is assessing the quality of the new or newly discovered fact and its implications, I would submit it's inconceivable the court won't tell in its own reasoning what that fact does or what it signifies, i.e. the person couldn't have been at the crime scene, or the DNA evidence demonstrated it wasn't that attacker, or the new CCT evidence shows the person wasn't assaulted at all, contrary to what was claimed, those sorts of things. And the assessment of the evidence will, in the Criminal Division Court of Appeals reasoning, enable a ready application of 1ZA based on those factors. Can I turn to just the legal context, some of which the second topic I just wanted to cover, and that is the background to Section 133. Can I just make 5 points about that, beyond those which you've already got in our printed case? The first is, as referred to in our printed case, the observations of Lord Bingham in the case of Ree McFarland, and that case is in Bundle 2, e-reference 1077, but the paragraph we've actually set out in the printed case itself, it's paragraph 6. And I make this reference, or provide this reference to the court, partly in answer to the intervention from justice, which is directed at plea for a wider definition of miscarriage of justice. But as Lord Bingham identified in paragraph 6 to 7, the question of payment of compensation for what are perceived as miscarriage of justice, itself a term capable of considerable different definitions depending on who you ask, is one which is fraught with difficulty and ultimately, in my submission, for the reasons stated, a policy decision. And of course, the case of Adams itself illustrates that in the absence of a definition of miscarriage of justice provided by the legislature, there is obviously scope for wide divergence of views. I mean, in that case, a 5-4 split as to what the term left undefined meant. The second point I'd make linked to that is that there is no general entitlement to payment of compensation for a person being exposed to the criminal process, even if that results in a conviction which is subsequently quashed, whether on appeal in time or not. And that is an important principle when you examine the Strasbourg case law. I'll come to these cases in a moment. There are a wide variety of different schemes across the Strasbourg jurisdiction where compensation is provided, sometimes, for example, for pre-trial detention, notwithstanding no trial at all, and others in different circumstances. They are voluntary, if I can use that word, in the sense that states can decide to offer such compensation, but they are not required pursuant to any international rights, such as that under Article 14.6. And the repeated point in the Strasbourg case law, which is important, is refusal of compensation per se does not offend the presumption of innocence under Article 6.2. The third general point is that whilst there are other important remedies for becoming involved in the criminal process where it goes wrong, such as claims for unlawful detention, claims for malicious prosecution, and of course the right to or ability to seek costs, defendants' cost orders in appropriate cases. The only right to compensation that exists in this jurisdiction is that articulated in section 133, which is intended to give effect to Article 14.6. The fourth general point is one I've just already touched upon, but that is to appreciate the limited nature of that article right. And one can do the exercise by reference to section 133 itself, which is in Core Volume 1, electronic page 679. On its face, section 133, subsection 1, has a number of significant inbuilt restrictions on when compensation has to be paid, and these reflect Article 14.6, so I don't turn up that separately, but it's been analysed in a number of cases. You can see there is no right to compensation where a person is charged and then acquitted, or merely having been suspected of a crime, no matter how long the detention, pre-trial detention may have been, or the circumstances of the suspicion. And that immediately contrasts with the sorts of schemes that were an issue in Sekanina, Hallam, and Capo, the cases you were taken to yesterday, which are all about voluntary schemes which go beyond that which Section 133 and Article 14.6 require. Secondly, there's no right to compensation where an appeal is a conviction's quashed on an appeal which is made in time. And that doesn't matter how egregious the conviction might have been. Serious misdirection to the jury, inadmissible evidence being used. Those sorts of things don't give rise to any right of compensation under the article right, or indeed DNA evidence being overlooked completely. Thirdly, even on an appeal made out of time, there is no right to compensation where the conviction's quashed on anything other than a new or newly discovered fact. And so there is no right of compensation for an error of law. And there are, I said I'd just give you the examples of that. The case of Bateman and Howells, which is in bundle 2, electronic reference 984, is the case I referred to a moment ago. It's tab 13, I think.
14, isn't it?
I'm so sorry, it is tab 14. Page 984. In that case, Lord Bingham dealt with 2 appeals for refusal of compensation. The case of Miss Bateman, did I say Bateman? I'm so sorry, it should have been Miss Howells. It was Mr. Bateman and Miss Howells, I'm so sorry. Miss Howells was someone who was convicted of a breach of a bylaw, as explained on page 985, in relation to the Greenham Common bylaws. Subsequently, the bylaws were quashed in the case of DPP and Hutchinson, and she then applied to have her conviction quashed, which it was duly quashed on an appeal out of time, see the top of 986. But there was compensation was refused on the basis that it wasn't quashed by reason of a new or newly discovered fact. And Lord Bingham upheld that decision, along with that of Mr. Bateman. Mr. Bateman, you can see from page 987, was someone who was convicted after evidence had been admitted against him, but not subject to witness evidence, not subject to cross-examination, and that's explained at 987 to 988. He spent 3.5 years in prison on the strength of that conviction, which, as is said at letter B of page 988, should never have been recorded. But again, by reference to Article 14.6 and Section 133, no compensation right arose. And Lord Bingham explained that, Sir Tim, then sitting as Master of the Rolls, at pages 990 and 991. Can I just draw the Court's attention to what's said between letters E to G on page 991? D to F. Therefore, it follows, he says, he's a victim of a miscarriage of justice, and that passage down to which I now turn. Point is made that Article 14.6 is not a right which gives compensation to those who consider they've been subject to a miscarriage of justice in any general sense, but it's a restricted right by reference to very strict criteria, which I've just explained. And in those circumstances, I come to the the fourth general point is on the face of the Section 133 and Article 14.6, a point that I've just made. It's not sufficient that there be a new or newly discovered fact. There is the requirement for it to have a conclusive effect, which has been translated into the beyond reasonable doubt test. And that was considered, of course, in Adams, leading to the Category 2 construction. And finally, on the general scheme, it's clear that Article 14.6 coexists with its own presumption of innocence right in Article 14.2. And you probably just need to see that, the International Covenant on Civil and Political Rights, which is at page 723, Volume 1, tab 6. And on page 724, under Article 14, you can see Article 14.2, everyone charged with a criminal offence shall have the right to be presumed innocent until proved guilty according to law. And then Article 14.6 is on the opposite page, which is the Article Rights section 133 gives effect to. And the significance of that, of course, is that it is relevant to consider how the international covenant is construed in relation to Article 14.2, the presumption of innocence expressed in exactly the same way as Article 6.2 in the Convention. And the Human Rights Committee, responsible for the International Covenant in this respect, in the case of WJH and Netherlands, has made it clear, so far as it's concerned, and that's in Volume 6, tab 71, beginning at 2372, and this decision where WJH complained of a breach of Article 14.2 and Article 14.6 against the Netherlands, having been charged with forgery and fraud, and then is subsequently being acquitted but denied compensation. If one looks at the bottom of page 2374, with respect to the author's allegation of a violation of the principle of presumption of innocence enshrined in Article 14.2, the committee observes that this provision applies only to criminal proceedings and not to proceedings for compensation. And accordingly, it finds this provision does not apply to the facts as submitted.
Usually we're told who the members, or sometimes I think in modern decisions, we're told who the members of the Human Rights Committee are. We aren't told here.
No, I haven't been able to locate who the members were. It is a decision which I think dates from
1992.
Yeah. There hasn't, so far as we've been aware, any change in that analysis from the Human Rights Committee, positive or negative in the sense that there isn't a subsequent decision. But can I just...
And this committee is charged, is it, under the International Covenant with overseeing implementation of the covenant?
Exactly. Dealing with these complaints where they're brought against countries for breach of the covenant rights. I'm reminded 726 of the bundle, there is the article which explains, Article 28 explains the composition, nationals of the states parties to the covenant, persons of high moral character and recognised competence in the field of human rights, which doesn't answer.
No, I mean, they're quite interesting to see, and they are hopefully distinguished experts, but it can
I'm afraid I can't
be of interest.
Elaborate further on. Just whilst we're on decisions of the International Committee, in case it were thought that the domestic interpretation of Section 133 in the restricted way I've indicated is somehow anomalous, that we have provided cases in our printed case which demonstrate the same approach to the restrictions on Article 14.6, And can I just give you the references? Mahonen against Finland in volume 6, tab 70, electronic reference 2365, someone who was pardoned as a result of considerations of equity was not entitled to compensation because that did not constitute a new or newly discovered fact. And in the case of Irving in Australia, same volume, tab 72, electronic reference 2376, a case where there was manifest injustice as described, but no right to compensation because Mr. Irving had been acquitted after a final appeal rather than an appeal out of time, albeit it had taken quite a long time.
But neither of those go, do they, to the interrelation between 14.2 and 14.6, or do they?
No. It's just they go to the other restrictions that I've indicated.
Yep.
It's only WJH which deals specifically with that point. And again, if I just want to make it plain, Article 3 of Protocol 7, of course, is the European Convention equivalent of Article 14.6, albeit the UK is not a signatory to Article 3 of Protocol 7 or Protocol 7 at all. But where that has been considered by the Strasbourg Court, there are two cases before the court. The case of Matveyev in volume 5, tab 51, page 2090. The Strasbourg Court adopted a similar restricted approach. In that case, Mr. Matveyev had been convicted of forgery of a postal stamp and sentenced to 2 years imprisonment in 1981. His conviction was subsequently overturned in 1999 on the basis that no crime could have been committed because the stamp in question hadn't been one that could have been considered valid, so he couldn't have committed any offence of using it. The facts are a little bit more intricate than that, but the principle being that he couldn't claim compensation or a breach of Article 3 of Protocol 7 because the acquittal, many years later, had not been on a basis of a new or newly discovered fact, but just a reinterpretation of the laws in question by a different court subsequently. And then Bakowski and Poland, bundle 5, tab 53, page 2128. Mr. Bakowski, convicted of disseminating false information in 1959, when Poland was under the control of the USSR, sentenced to 2128. Sentenced to 3 years imprisonment. In 2001, the Supreme Court allowed an appeal against that, finding there hadn't been any dissemination of false information of the type that had been claimed in 1959. He complained about the amount of compensation he was awarded, and the European Court found it had no basis for looking at the complaint under Article 3 of Protocol 7, because again, it was not a reversal based on a new or newly discovered fact. All of those cases illustrate, in my submission, a recognition that the right to compensation under Article 14.6 and its equivalent in Article 3, Protocol 7 include very strict limitations on the right to compensation, and application of those strict criteria does not involve any necessary infringement of the article right itself. The two Strasbourg cases don't, of course, consider Article 6.2, so I don't rely upon in that respect, but I have taken you to WJH in the Netherlands. All of this demonstrates, in my submission, that Article 14.2 coexists with Article 14.6 without the two needing to overlap. And that is the view expressed, as we know, by the Human Rights Committee, but it is also the view that was expressed by Lord Steyn in the Mullin case, paragraphs 35 to 46, electronic reference 765 to 769. And I think I should probably take the court to that, in particular, paragraph 38. It's volume 1, tab 7. Lord Steyn, paragraph 37 onwards, dealt with the impact of Article 14.2 on Article 14.6. And I think the court was taken to this passage at letter E, where Lord Steyn, having looked at the two article rights, concluded, on the contrary, the obvious and sensible construction is Article 14.6 as a lex specialis, and the general wording of Article 14.2 does not warrant either an expansive or restricted reading of Article 14.6. The latter provision creates an independent fundamental right governed by its own express limits. Indeed, I've taken you to the nature of those limits. And then he made reference to the WJH case. I think it was submitted that Lord Steyn may have been hoisted on his own petard in introducing Article 3 of Protocol 7 by way of a comparator. But in fact, if that submission was made, it's not a fair one, because in paragraph 39, Lord Steyn deals with the argument that was put based on Article 6.2 and its correlation with Article 3 of Protocol 7. And in the subsequent analysis of the Strasbourg case law on Article 6.2, Lord Steyn, in my submission entirely correctly, analyses each of the cases that predate, obviously, Hallam. That is, all of the Seconina, Rushiti, Hammond type cases, to emphasize that the interaction between Article 6.2 and Article 3 of the 7th Protocol was not under consideration. You can see that at page 41D. The Strasbourg Court, in all of those preceding cases, has never had to consider the discrete question of whether Article 14.6, or in its jurisdiction, Article 3 of Protocol 7, is indeed a lex specialis. And that leads to the conclusion at paragraph 44. European jurisprudence cited throws no light on the question of whether Article 6 justifies an expansive interpretation of Article 3 of the 7th Protocol, or the corresponding question in respect of Article 14 and Article 14.6. And the principal analysis, therefore, must prevail, and the lex specialis point. That, of course, is the same conclusion reached by Lord Hope in the Adams case, but with the added point that Lord Hope had obviously distinguished Lord Steyn's analysis of a narrower definition of miscarriage of justice. Lord Hope was one of the majority that rejected Lord Steyn's narrower test of a miscarriage of justice, but nonetheless, Lord Hope in Adams, paragraph 108 to 111, went on to conclude on the separate question that Article 14.6 was indeed in the form of a lex specialis, where Article 6.2 had no purchase. And that begins at page 892 of the electronic bundle. So there is no overarching purpose of compensating all those who are wrongly convicted. and no breach of Article 6.2 in not having any wider compensation scheme per se. And we do submit that the reasoning, the comprehensive reasoning as to why Article 14.6, in conjunction with Article 14.2, is indeed a lex specialis, continues to hold good.
Would you just do a quick bit of head counting? It may not be ultimately relevant, but there are an awful lot of heads in certainly Adams. How many agreed with Lord Hope, and similarly, how many agreed with Lord Steyne in the earlier case, Mullen?
I put it at 8.
I didn't say anything.
Well, I say the reason I say that.
Is that why you put it at 8?
I put it at 8 because, and I think we've, in fairness to my lady, we have put in our printed case the reason why we included your ladyship in that number, and we distinguished Lord Clark, who expressly said he wasn't convinced about lex specialis. And the reason why we made that submission is that your ladyship agreed with Lord Phillips, and it was a necessary part of the case in Adams, or a necessary freestanding part of the case in Adams, as we've seen in argument, that it had to, the categories had to comply with the presumption of innocence, because there was a freestanding challenge to the categorization based upon infringement of the presumption of innocence. So that's
Maybe a bit ambitious.
Well, your ladies and
to construe my very short judgment.
You're in a much better position than me to construe it.
It was a long time ago.
But that's our reasoning. But in any event, 7 express in our submission expressly so, 8 depending on the construction my lady places on her judgment.
It depends on the construction we place on it, doesn't it?
Well, yes, that's probably correct.
Nobody has the right to construe their own judgments.
No, that's absolutely
right too.
Really, the landscape has shifted a good deal since then, hasn't it?
What about the earlier
well,
case?
I'm coming to the shift in the ground in Hallam. Sorry.
What about the earlier case? Who agreed with Lord Steyne?
Lords, well, I think I recall Lord Hughes in Hallam.
Well, that came later.
Court of Appeal.
No, I was
What
sorry,
about in Mullen?
in the House of Lords itself.
don't.
I have to, my Lord, can I save that to do an account and come back to you on that?
Yeah.
Lord, just to be clear, Lord Phillips in Adams agreed with my Lord Hughes in Hallam. So he agreed with both Lord Hope's reasoning in Adams, but also your own reasoning.
Yeah, that's right.
In Mullen, did not Lord Scott, Lord Roger and Lord Walker agree with Lord Steyne?
I believe so. I don't want to commit myself because I needed to check, but I think it was something that certainly
Looks like it.
looks like it. Yeah. That is all I want to say by way of the legal context. It just brings me neatly onto the first core submission about the applicability of Article 6.2. I don't take the court back through the analysis in the Adams case because your lordship and ladyship are aware of the analysis from the references I've given you. But we do say it is of a definitive assessment based as it is also on Lord Steyne's analysis and my Lord Hughes in Hallam. And in those circumstances, the question arises of whether the Strasbourg Court in Hallam itself displaces that reasoning sufficiently for this court to overrule its previous decisions. And we submit that it should not. I make the following 4 observations. The first is that contrary to any indication yesterday, you can't describe Hallam and the UK as representing a clear and constant line of authority on this point. Because whilst I would accept the Strasbourg Court has a constant line of authority in extending Article 6.2 to what I described as voluntary compensation schemes, i.e. those schemes which aren't reflecting Article 14.6 rights. there is no authority that we're aware of prior to Allen which applies or seeks to apply Article 6.2 to the sort of Article 14.6 type compensation scheme, or indeed Article 3 of Protocol 7, with all of the lex specialis points that arise. And you'll see that when you revisit Sekanina, Hammond, Rashiti, and indeed Capot. And indeed the indications up until you get to Allen suggested otherwise. In the Sekanina case itself, I think you were taken to this reference yesterday, volume 5, electronic reference 1858. Sorry, I might have got the wrong volume there. Sorry, it's volume 4. Apologies. The observation in the judgment in Sekanina on paragraph 25, that having referred to diversity in the laws of countries providing for compensation, in the majority of the award of any compensation is made conditional on the claimant's conduct prior to or during the trial, or it's left at the discretion of the courts. In addition, despite certain similarities, the situation in the present case is not comparable to that governed by Article 3 of Protocol 7, which applies solely to a person who has suffered punishment as a result of a conviction stemming from a miscarriage of justice. And whilst I, again, accept it's not expressing a definitive view on applicability or violation, it's certainly drawing a distinction between those voluntary type schemes as compared with schemes that have their provenance in Article 3 of Protocol 7 or its analogue in Article 14.6. And in the Hammond and Norway case, you were taken to the concurring opinion of Judge Grieve, and the Hammond and Norway case is in Bundle 4, tab 42, beginning at electronic reference 1980. This was, again, another case of a voluntary compensation scheme which went beyond any international covenant requirements. The concurring opinion of Judge Grieve at 1996 made precisely that point, that the Norwegian system, page 1997 at the bottom, had introduced a wider compensation scheme under Article 444 of its Criminal Procedure Code, with the intention of allowing additional people to claim compensation where they could establish on the balance of probabilities they hadn't committed the offence, generally. And because that was found to infringe Article 6, it had the unfortunate effect of a scheme intended to extend compensation was found to fall foul of Article 6.2, a somewhat strange result.
But why would the application of the presumption of innocence to voluntary schemes not also mean that it applied to a convention scheme?
Well, two reasons, in essence, my lord. The first is that as we've seen in the context of the international covenant, Article 14.2 and Article 14.6 coexist but don't need to overlap. And the reason for that is that Article 14.6, by its restrictive terms, is assessing a right to compensation in very limited circumstances where someone has been acquitted, and then establishing right to compensation by reference to prescribed criteria. But the application of that scheme in the very circumstances of known acquittal, but limiting it to prescribed circumstances, is not going to call into question that person's acquittal generally. Indeed, it's a basic premise of the scheme itself, that they are indeed treated as innocent and in consequence of the acquittal, it then becomes a technical question of whether they satisfy the more limited criterion for a miscarriage of justice. And the second answer to my Lordship's question is that in the voluntary schemes, as I'm going to show you, the vice that's identified, including that in Hallam, is of a scheme which requires an assessment of someone's innocence generally, often with a presumption that they need to establish their innocence generally, notwithstanding an acquittal. And each of the schemes, I'll show you in a short moment, in my submission, that were found wanting were precisely that type of scheme. So in the case of Hallam, which we were looking at a moment ago, Article 444 of the Norwegian Code comes into play after someone is acquitted, but requires one to start with a presumption of having to prove on the balance of probabilities you didn't commit the offence. That, of course, is a very different scheme to that which applies under the limited criteria under Article 14.6, which is all about analysing what constitutes a miscarriage of justice. So for those two main reasons in my submission, the court was always right to conclude that Article 14.6 schemes are a lex specialis in the context of Article 14.2. The same won't necessarily be capable of being said of voluntary schemes that go beyond that lex specialis.
Well, Article 444 in Hallam is at 1987, isn't it?
Yes.
If acquitted or discontinued, 1987, if acquitted or discontinued, may claim compensation if shown to be probable that he didn't carry out the act. Well, that has to coexist with Article 6.2 as well, doesn't it?
Article 4.4 on the Strasbourg analysis has to coexist with the Act because it goes beyond the lex specialis of a miscarriage of justice scheme prescribed under Article 3 of Protocol 7 if you're looking at the Convention, or Article 14.6 if you're looking at in terms of the International Covenant.
Because it's not found in the same instrument as the presumption of innocence. Is that it?
Not because it's not found in the same... I think in Article 444, it's a domestic compensation scheme, and its scope is beyond that of a miscarriage of justice scheme.
Yes.
It's a general compensation right if you can show it's probable you didn't carry out the act for which you've been charged. If the Norwegian system had a compensation scheme confined to assessment of miscarriage of justice, tracking Article 14.6, then for the reasons that I've explained, there would be no application and no need for application of Article 14.2 or Article 6.2. But I was in the Judge Greaves' comments in Hallam. Mm-hmm. Can I just ask you to note her comments at the bottom of page 1998.
We have no idea what a miscarriage of justice means in terms of the ICCPR.
No, my lord. You know what the Supreme Court looked at in the Adams case in order to find out whether there was a specific definition. The broad conclusion is there isn't. It's left, and perhaps deliberately so, as a term to be applied by contracting states to decide for themselves. But Judge Grieve distinguishes Article 4.4 from a scheme under Article 3 of Protocol 7, the bottom of 198. It's formulated in a manner indicating it's only where a miscarriage of justice has already been established that there will be scope for mandatory compensation. She refers to the circumstances in which it's applicable, and such compensation decisions are taken by law enforcement authorities. Although in their decision-making and compensation they revert to the issue of the guilt of the former accused, they do so only in a context in which the initial person was initially found guilty, but the conviction was quashed or person pardoned. The issue of guilt is not reopened in the compensation proceedings. And there, albeit it's merely a concurring opinion, but certainly in concurring with the Strasbourg view, Judge Grieve is actually making the very point that Lord Phillips makes in paragraph 58 of section 133, giving effect to Article 14.6. If you are applying them on its terms, you don't reopen the question of guilt, innocence in the compensation proceedings. You're looking at some very strict criteria as to whether a miscarriage of justice has already been established. Article 444 was going beyond that and fell foul, consequently, of Article 6.2. And the same applies to O and Norway. I don't need to, it's exactly the same scheme, and indeed another concurring opinion. The second point is Hallam and the UK itself. That's in Bundle 1 and tab 11, beginning at 940. And the question is whether the Strasbourg Court has dealt with the key reasoning in Adams and Allen as to the inapplicability of Article 6.2. And by way of analysis, if one turns to page 3, the court's assessment of applicability is dealt with, and you can see reliance is placed on by the appellants at paragraph 94 as to the general aim of Article 6.2. The general aim in this second aspect is to protect individuals who've been acquitted of a criminal charge or in respect of whom criminal proceedings have been discontinued from being treated by public officials and authorities as though they are in fact guilty of the offence charged. I'm pausing there. If that's the aim, in my submission, there is no conceivable way that a scheme such as that under section 133, 1ZA, reflecting Article 14.6, can have that effect. There is also the aim mentioned potentially of extending protection to a person's reputation at the end of paragraph 94. But again, I make precisely the same point. None of that deals with the lex specialis reasoning that you find in Adams. Then on applicability, which is the reasoning on applicability, you have at 95, 96, 97 and 98 an analysis, conventional analysis of Article 6.2. The first part of the analysis is to recognise that Article 6.2's normal application has no bite, and that is paragraph 95, because there's no criminal charge involved in compensation proceedings. So 96 is a conclusion that those tests normally applied are inappropriate. If it is engaged, it must be engaged on different grounds. Well, that's clearly right. It doesn't answer the question whether those grounds are sound. 97, 98, 99, 100, 101, and 102 are an analysis of where the Strasbourg Court has applied Article 6.2 in different circumstances, but not to Article 14.6 or Article 3 of Protocol 7 schemes. It is a recitation of what the court has done in the past in applying Article 6.2 to other compensation schemes. But none of that provides any reasoning as to why it should then apply to this type of situation. And that's where one gets the references to consequence and necessary concomitants of, paragraph 99, or direct sequel to, or linkage of questions. That is indeed the case law that applies to voluntary schemes, but not, and never has, to the scheme we've got in play here. And the conclusion at 103 begs the question. The conclusion is that formulating the principle of presumption of innocence in this context means that where there's been a criminal charge and a criminal proceedings have ended in acquittal, the person who's been the subject of criminal proceedings is innocent in the eyes of the law. Yes, indeed, we would say, and must be treated in a manner consistent with that innocence. Yes, indeed, but that does not, would not, in any shape or form be infringed by the application of a miscarriage of justice criteria of the type in section 133. 104 then repeats the linkage argument. That merely is saying that's the approach we've applied in the past. And then we come to the only paragraph that deals with the lex specialis analysis that's been applied in the domestic case law. Paragraph 105. The first sentence is the assertion, i.e. the fact that the scheme comes from Article 14.6 doesn't mean it's outside Article 6.2. Well, that's the assertion, it's not reasoned. And then the reasoning follows. The two articles are concerned with entirely different aspects of the criminal process. Pausing there, that is actually reasoning which supports the principle of a lex specialis as applied in the Adams case. They are indeed separate parts of the criminal process. The Article 14.6 process applies in the way we've looked at after acquittal on the basic presumption that someone is innocent, but to investigate whether there's been a miscarriage of justice. So that is, in anything, pointing the other way. And then it said there's no suggestion Article 3 of Protocol 7 was intended to extend to a specific situation general guarantees similar to those contained in Article 6.2. Well, it already has inherent in it the protection that its limited criteria are applicable to someone who has been acquitted. And that is why both the Human Rights Committee and this court in Adams, and Lord, I respectfully say my Lord Hughes in Allen, were identifying there is no need or apposite requirement for the imposition of Article 6.2. And then the final point of reasoning, Article 7 of Protocol 7 clarifies the provisions of the substantive articles are to be regarded as additional articles and shall apply accordingly. Well, first of all, that is entirely neutral as a statement. It doesn't tell you whether or not you need to import Article 6.2 into the equivalent of Article 3 of Protocol 7. And secondly, the case of, I'm not going to be able to pronounce it either, Malia in France, referred to in the footnote, is actually a decision which points the other way. It's a decision making it clear that notwithstanding that principle, you don't always apply Article 6 to all aspects of the other article rights. And then one gets inclusion, Article 3, and I should add, of course, the UK is not signatory to Article 7 of Protocol 7, so why it should bite upon Article 14.6, which is what Section 133 is reflecting, is not clear at all. And then the assertion, again, Article 3 of Protocol 7 cannot therefore be said to constitute a form of lex specialis, excluding the application of Article 6.2. So in my submission,
Mr. Strawn, I'm afraid I'm being very slow, but at the moment, and I reread it 4 times, I don't understand the sentence in the middle of 105. There is no suggestion that Article 3 of Protocol 7 was intended to extend to a specific situation general guarantees similar to those contained in Article 6.2. What's the point there being made?
well, my lord, when I first read that some time ago, I read it as actually a reason that pointed in our favour, i.e., there's nothing in the Article 3, Protocol 7,
Yes.
which says you're intending to import Article 6.
But?
So that would be,
Yes.
yes, we would say, yes, indeed.
But
that's
then you
another-
read it.
But
then
what
you
I,
read it a
then I've
different
read
way.
it, I think what the court is saying
Yes.
is that because it doesn't say anything about Article 6 within Article 3 of Protocol 7, you have to read in Article 6 to give you the protections into Article 3 of Protocol 7. That's how I understand the reasoning. If that is the reasoning, it is almost a bootstrapped argument in a
It's
sense,
circular,
because
isn't it?
it's saying because it's not there, you need to read it in. But the prior question is, why do you need to read it in at all? If you stick to the criteria that are set in Article 3 of Protocol 7 or Article 14.6, if you apply them faithfully, you don't ever get into the territory of undermining the acquittal at all. And that's the point we respectfully say the majority or this court domestically was made by Lord Steyne and Mullen, made by, in the Allen case itself. So this reasoning, I respectfully submit, is certainly short. It's difficult to comprehend.
I think it's easier to comprehend if you look at the paragraphs 36 and 37 of Maui against France, because there was a different scheme, but basically the court was concluding that the scheme clearly intimated an intention that Article 6.1 should not apply. So what they seem to be saying here is that there's nothing in Article 3, Protocol 7 to suggest that it's overlapping with or intended to exclude Article 6.2.
If that supports the second reasoning that I came to, then so be it. I simply make the point that the absence of reference to Article, or excluding Article 6, doesn't of itself mean that it needs to be in there. And I was just going to conclude on this point, because this is the reasoning, effectively dealing with the Lex Specialis point. It doesn't deal with at least 3 important things. It doesn't deal with the fact that this is now an interpretation which is at odds with the Human Rights Committee and its interpretation of the International Covenant. And true it is that there was reference earlier to the WJH Netherlands case in the judgment, but there's no analysis or recognition that this is at odds with the Human Rights Committee's interpretation of Article 14.6.
Well, didn't they say that things had moved on since then, or something like that?
I don't
Where's the
so.
reference to WJH?
It's in, I think it's in recording. What?
It's paragraph 85.
Yes, it's recording our submission.
And that's it, is it?
I believe so.
Thank you.
Well,
Secondly, it doesn't deal with the reasons or the Lex Specialis arguments that are set out in detail in Adams and Allen. And thirdly, in relation to Soccer and Gale, and the question of dialogue on that issue, I just simply note that, and by way of an apology on my part, Soccer and Gale was not cited to Strasbourg court in this case. I say that because I was involved in the case. There is no suggestion that the cri de coeur, as it was described, is one that the Strasbourg court was confronting in this case, nor obviously analysis of the judgments where question marks are raised as to how Article 6.2 is being extended beyond its natural scope. So it's not a criticism of the Strasbourg court, but equally it is a point that they haven't, if the point is being made against me, taken up the challenge of the constructive dialogue that arose in part from that case in this judgment. And when one then turns to the application of the general principles to the facts of the case, you can see 106 to 109, they simply apply the test of linkage that they've adopted earlier. Importantly, if one turns later on in the judgment to paragraph 128 on page 971, the court is here dealing with the different point of the merits of the complaint of a violation of Article 6. And it's only in that context, paragraph 128, when concluding there's no violation, that the court actually deals with the restrictive criteria that apply to Article 3 of Protocol 7 and Article equivalent Article 14.6. So the restrictive criteria are used by the Strasbourg court as part of the reasoning to demonstrate no violation, because they had to be read consistently as sitting alongside Article 6. But in fact, the prior point, which is the reasoning in Adams and Hallam and Hallam, the prior point is it's those very restrictive criteria which make it a lex specialis, not engaging Article 6.2 in the first place. And so what the court, Strasbourg court, has done, or not done, is confronted that argument, the nature of the restrictive criteria and their consequence, as meaning there's no need for Article 6.2 to apply. Ironically, when they come to look at them, they use them as a reason for showing no violation. So it might be said, well, you get to the same end result. You apply Article 6.2, you then find it not violated if you're applying the restrictive criteria. I can see that. But equally, as an argument of principle, these are points as to why Article 6.2 has no obvious purpose in this context. And the third point to make about the Strasbourg court's jurisprudence, if Article 6.2 is introduced into this context, it does, of course, bring with it all of the other concerns, if I can put it as neutrally as that arise and how you apply it in cases of this kind. What constitutes voicing of suspicions which are acceptable, what are not? Category 2 is apparently acceptable, but it's now being argued Category 1 is not. The unsatisfactory decisions that cross over between the criminal and civil liability, about which Strasbourg judges themselves have expressed concerns. And the Orr and Norway case is a very good example. Once you introduce the question of the need to conform with language requirements, what does that actually mean? The Orr and Norway case, could I just turn that up? Volume 5. Tab 52, electronic reference 2101. The facts of the case relate to an alleged rape described in paragraph 5 through to 8. The individual was acquitted at trial of the rape, but ordered to pay civil damages on the basis that whilst the court was satisfied there wasn't proof to the criminal standard, the civil standard had been met. And the judgment explaining that's at paragraph 9 on page 2103. And the explanation of findings on the balance of probabilities are explained in detail in that judgment. And the court expressed itself clearly, the domestic court expressed itself clearly as making a decision on the balance of probabilities and not finding any criminal liability. And that's repeated at page 2106 to 2107. The Strasbourg court accepted, in principle, one could find civil liability at a lower standard of proof. But if you turn to 2117, paragraph 51, you will see exposed the very dilemma that was raised in argument yesterday about what language does one use in describing facts which constitute the same effective incident, albeit not proved to a criminal standard. It's paragraph 51. The offending word appeared to be the use of the word violence to describe the incident, bold, to accomplish the act and intent in this respect. Recognising it covered practically all the same constitutive elements, objective as well as subjective, that would normally amount to the criminal offence of rape, it's true that, as stated in the case law above, an acquittal for criminal liability doesn't bar a national court from finding on a less strict burden of proof. However, where one went on, the court considers, although the concept of violence may not have been exclusively criminal in nature, the use made of it by the High Court in the particular context did confer criminal law features on its reasoning, overstepping the bounds of the civil forum. And there were some dissenting judgments, opinions, 2122, and 3 dissenting opinions out of 7 judges, and 2125, which go into some detail, I won't read them out, as to the acute difficulties of that reasoning.
This is a chamber decision. I mean,
It is.
I wonder how much weight it's worth. I mean, has it been followed expressly on this point?
Well, I think it's certainly not been disapproved, but I think it's probably referred to in Nealon itself. I'll check again.
Well, it's certainly referred to in Hallam, and pick up the places. But it may only be in submissions.
Well, my submission, what it clearly feeds into in Hallam is the point made on the question of violation, paragraph 126. Indeed, it in fact, or is referred to in this context. Paragraph 126, in all cases, no matter what approach applied, the language used by the decision maker will be of critical importance. And then the examples are given. A case where it was clearly probable the applicant committed the offence of which he was charged, the court found it had overstepped the bounds of the civil forum and thereby cast doubt on the correctness of the acquittal. And then you'll see the footnote, see why, see also or at paragraph 51. So,
Well, that's a slightly different thing, though, isn't it? I mean, it's not true that if you find on the civil balance of probability that someone committed an assault, a rape, you're casting doubt on the correctness of the acquittal.
Yeah.
But my lord,
Perfectly consistent indeed. I mean, you
didn't-
would say that.
they didn't. The decision in all wasn't a finding that he'd committed rape. It was a finding that he'd used force.
Yes, all right.
And that was the offending language.
I'm sorry, maybe I shouldn't have used the word rape, but it's not true that it's even less true perhaps, that you're casting doubt on the correctness of the acquittal. There seems to be a fundamental problem about the reasoning in 126, insofar as it cites this case, in other words.
Well, my lord, I obviously that's a cause of the submission I've just made. Once one introduces Article 6.2 into this context, you are, according to the Strasbourg case law, introducing the concept of language, and the language you use being the thing that can tip the balance. And
but only if the language does actually cast doubt on the correctness of the acquittal.
Lord,
Which
yes,
if you're finding on the balance of probabilities that there was violence, you're not doing, because you're adopting a different test.
my lord, I would entirely agree with that observation, but that's not the analysis of Strasbourg.
Well, is it not? I mean, para 123, the court seems to me to be making the point that Lord Mance has just made. And the problem at 126 is the particular language that was used in saying that the applicant had committed the offences of which he was charged, or in the next example,
Yes.
that there was enough evidence to establish that a criminal offence was committed.
That was the case in Y, but then they say see also, or in Norway, paragraph 51. And that's a paragraph I've just taken to you, where the language problem was using the word violence, which caused difficulties. I see
Yes.
time.
Is that a convenient moment for you?
It is, my.
How are you doing for time? Are you all right?
I shall probably have to speed up a little bit.
Well, we'll have to try to avoid putting so many questions to you then.
My lady, would the court excuse my attendance this afternoon? I'm in the middle of an ongoing trial.
Yes, we will. Thank you very much. Court will now adjourn until 2 o'clock.